I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast. I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all the past. And the pettiness, a reflection of the emptiness. Hilarious, you think you're worth my time, you're delirious. Mysterious, because you hide behind a fake exterior. Inferior, you know I'll always be a bit superior. Get off of me, this ain't no humble brag. I want you to hear words, you can say them back. I want you to feel free from the chains at last, and to believe in what you got, it was built to last, yeah.
Now that I've been put through hell, I never got anyone's help. I had to do it all myself.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Gonna learn the consequence of being incompetent. Mental health is confidence, dreams and some honestness. I'm not here to save the day, that's for you to take away. I could play a million mind games, but instead I say something not illogical, something that is topical. Rub it on and watch it go, make yourself unstoppable. Dreams are irresponsible, but they're always possible. If you just believe, you could be so remarkable.
Thoughts in my head, a collage and they spread. I'll be great one day, going off of my meds. No I'm not giving up, no I'm not giving in. I will make it to the top, taking off in the wind. I gotta make it, I'm saving every day to taste it. I'm patient, but my mind, it can hardly take it. I'm chasing a dream that I've had for several ages. A vacant, modern kingdom for the taking.
Now that I've been put through hell, I never got anyone's help. I had to do it all myself.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take.
Come over, you can just set up here and stay here. If you want to come over to get a photo or two or get some photos, you can't stay here like permanently. Jurors come in and out of this door. My staff comes in and out of this door. You know, it's an egress issue too. So you can't just set up and like stay here the whole time.
So we'll go back over there. Got it. Okay.
Yeah, but like for just setting up, your own tripod and stuff. Yeah.
Well, we can still do it. It's only TV. Yeah.
And I suppose you can turn to the side for a couple of those.
I have to use track. Can you go to the other part? Can you supposed to be there and come to the crowd?
I mean, the attorneys typically stand over here to do their own statements, and so you probably can actually get pictures of them better. You have to be able to get nice photos from there. The lawyer's standing in the jury room there.
If I may,
So you're actually sitting over there probably because of the back.
right there where I'm standing,
They typically
this is
stand
better
in the
too.
back. You just gotta make sure you don't get the jury. So actually, you're
Okay, I will.
No, they typically stand in the well right in front of the,
All right,
jury.
we'll go. Thank you so much, appreciate it.
Hey, Judge. Hey, Judge.
All right.
You may be seated, everyone, please mute your cell phones. I know we have members of the family that still wanna come in here, that, I believe are out in the hallway and ready to come in. Is the jury all back in the jury room now? Are they in the hallway?
And Judge, if we can instruct the media to not video our client coming and going back to the back.
If you could avoid video him as they're bringing him in and out of holding, you can video him when he's at the table. But if the jury somehow sees any of these news that they're not supposed to, but if they would know he's coming from the holding in the back. So if you could just film him when he's at the table.
Okay, then we won't be able to see him. I mean, we'll see this back of his head. Okay,
Well,
just whatever you want.
Yeah, that's.
actually, when Mr. Brown stands up, he's gonna be right there, so.
Yeah.
So once he comes in he's by the chairs, then we're good to go?
Yes,
Okay,
you just can't get him coming from the holding area.
Okay.
all right, no problem. Thank you.
Discernment, what do we owe the pleasure?
I just had a few free moments.
Oh, okay.
Yeah, they're coming right through that first row, so you gotta.
I'll have to come over this way.
Yeah, way over.
Way over to the side,
Thank you.
out of the doorway. There we go. first, and then you can fill the last row. Are there any other members of the media outside of cameras that want to come in?
No, I went down and got everyone. There is a need to call up.
We've got most of the seating already taken up, so anyone who's in the first row, when we take a break, if the jury's gonna go out into the hallway, you're gonna have to exit that first row so that they can get, out of the courtroom, okay? Sometimes we'll send them back into the jury room, sometimes we'll send them out, so I'll indicate if you have to clear that first row or not. Okay? You ready to begin? There might be room for a couple more of you over in the first row if you want to use the first row, but, yeah, I don't know if you will. It's opening statement, so I don't know if you can do that. Yeah, we have to swear them to do it. We ready to go? Yes. Ready to see? Ready to drink?
All right, for the jury.
Everyone, please make sure your cell phones are silenced. Recalling case number 24-000535, People versus Michael Jackson-Bolanos. This matter's on the docket today for jury trial in progress. Appearances, please.
Good afternoon, Your Honor. Ryan Elsey for the people.
Dominic DeGrazia on behalf of the people.
And Brian Brown on behalf of Mr. Jackson-Bolanos.
Good afternoon, Jeff Turner, Christian RGT 82448, appearing on behalf of my client, Mr. Jackson-Bolanos, who appears to me to be great.
And I know for the record, Mr. Jackson-Bolanos is present. Our 16 jurors have returned to the courtroom, and we do have members of the press and public here now that we have more room available. We were admitting them as space became available during jury selection, but for most of the day yesterday, we had 65 jurors in here, and we're going through the elimination process as space became available. We allowed members of the public in, and again, this morning, we have another large panel plus our jurors from yesterday, and again, allowed people in as space permitted in the courtroom, and so we are ready to proceed. We do have our jury selected now, and we are ready to proceed with the preliminary instructions and then opening statements. And so first, members of the jury, you've been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. In a moment, I'm going to ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and to reach a true verdict. Could all the jurors please stand and raise your right hands? After the clerk has administered the oath, please respond by saying, "I do" or "I affirm."
Each of you do solemnly swear or affirm that, in this action now before the court, you will justly decide the question submitted to you, that, unless you are discharged by the court from further deliberation, you will render a true verdict, and you will that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court?
I affirm. Thank you, ladies and gentlemen. Please be seated. Now I'm going to read to you the preliminary instructions in this case. If you follow along best by reading along, they're in the binder that you were given. That is your binder for the duration of this trial. In addition to the instructions I'm about to read, you also will have a notepad for taking notes and a pen, and also some half sheets that are white in color that you can write questions for witnesses who are on the stand, and I'll explain the procedure and how we allow jurors to ask questions. And so if you follow along best by reading along, feel free to do so. If you'd rather just close the binder and listen to me as I read the instructions, that's fine too, whichever way you'll absorb the information best. Now, you do have a written copy of the instructions that I'm about to read to you, and you may refer to them during the trial. Since no one can predict the course of a trial, these instructions may change at the end of the trial. And at the close of the trial, I will provide you with a copy of my final instructions for your use during deliberations. And now I'm going to explain some of the legal principles you'll need to know and the procedure we'll follow in this trial. A trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but he may make an opening statement after the prosecutor makes his, or he may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine each of the prosecutor's witnesses. And after the prosecutor has presented all of his evidence, the defendant's attorney may also offer evidence but does not have to. Remember, by law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. And the prosecutor may also call witnesses to contradict the testimony of any of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. So the defendant is charged with 4 separate crimes, and they're, the sheets next to this instruction 2.4 list each of the elements for the crimes that are charged. And so I'm going to read them to you now. In count 1, the defendant is charged with the crime of first-degree felony murder. And to prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Samantha Heather Woll. That is, that Samantha Heather Woll died as a result of stab wounds. Second, that the defendant had one of these 3 states of mind. He intended to kill, or he intended to do great bodily harm to Samantha Heather Woll, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, that when he did the act that caused the death of Samantha Heather Woll, the defendant was committing or attempting to commit the crime of larceny and or home invasion in the first degree. For the crime of larceny, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant took someone else's property. Second, that the property was taken without consent. Third, that there was some movement of the property. It does not matter whether the defendant actually kept the property or whether the property was taken off the premises. And fourth, that at the time the property was taken, the defendant intended to permanently deprive the owner of the property. And then for the crime of home invasion first degree, the elements are first, that the defendant entered a dwelling without permission. It does not matter whether the defendant got his entire body inside. If the defendant put any part of his body into the dwelling without permission, that is enough to count as an entry. Second, that when the defendant entered, was present in, or was leaving the dwelling, he committed the offense of assault and battery. To prove the charge of assault and battery, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed a battery on Samantha Heather Woll. A battery is a forceful, violent, or offensive touching of the person or something closely connected with the person of another. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Samantha Heather Woll's will. It does not matter whether the touching caused an injury. And second, that the defendant intended either to commit a battery on Samantha Heather Woll or to make her reasonably fear an immediate battery. And third, that when the defendant entered, was present in, or was leaving the dwelling, either of the following circumstances existed. He was armed with a dangerous weapon and or another person was lawfully present in the building. So I know that's a lot of elements all together. And for count 2, the defendant is charged with the crime of first-degree premeditated murder, and to prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Samantha Heather Woll. That is, that Samantha Heather Woll died as a result of stab wounds. Second, that the defendant intended to kill Samantha Heather Woll. Third, that this intent to kill was premeditated, that is, thought out beforehand. And fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose his actions before he did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse without thought or reflection. In count 3, the defendant is charged with the crime of home invasion, first degree, entering without permission. And I just read the elements of this as part of the felony murder charge, so I'm not going to reread these elements again. They're the same elements I just read under the felony murder instruction. And then in count 4, the defendant is charged with the crime of concealing facts or misleading the police. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that Patrick Lane and/or Stephen Ford of the Detroit Police Department were peace officers who were conducting an investigation of a criminal offense. Second, that the crimes being investigated by Patrick Lane and/or Stephen Ford were larcenies or attempted larcenies from motor vehicles. Third, that Patrick Lane and/or Stephen Ford informed the defendant that they were conducting a criminal investigation. Fourth, that the defendant provided false information regarding that investigation to the peace officers in a statement or statements that the defendant knew was false or misleading. Fifth, that the defendant acted knowingly and willfully. That is, the defendant provided the false information voluntarily and intentionally with the intent to deceive, and not because of mistake or some other innocent reason. Sixth, that the allegedly false information provided in, Sixth, that the allegedly false information provided involved a material fact. A material fact is information that a reasonable person would use to decide whether to do or not to do something. A fact is material if it has the capacity or natural tendency to influence an officer's decision how to proceed with an investigation. You may consider whether the officers relied on the information in deciding whether it was a material fact. However, it is not a defense to the charge that the officers did not rely on the information if you determine beyond a reasonable doubt that the defendant intended to provide false information. It is not a defense to the charge that the officers were able to obtain the information from another source or by different means if you determine beyond a reasonable doubt that the defendant intended to provide false information. And so those are the elements of the charges that have been brought in this case that the prosecutor must prove beyond a reasonable doubt. And you may refer back to those elements at any time during the trial if you wish to do so. Now, my responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of this case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and all the testimony, and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Now, part of your job in deciding what the facts of this case are is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything that a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on the witness's race, national origin or ethnicity, gender, gender identity or sexual orientation, or religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? And all in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Now, when it's time for you to decide the case, you are only allowed to consider the evidence that was admitted in this case. Evidence includes only the sworn testimony of witnesses, the exhibits that are admitted into evidence, and anything else I tell you to consider as evidence. Now, the questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. Now, I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored, or to clarify something for the record. And you'll often hear me ask a witness, was that a yes or a no, if they shake their head or they give me an uh-huh or an uh-uh. Now, you may take notes during the trial if you wish. Of course, you don't have to. In a case this long, it is really helpful if you take notes during the trial when people are testifying, because we do not have transcripts readily available to give to you, at a moment's notice. It could take a couple of days to get transcripts prepared and give it to you. So if you take notes about what people are saying and things that you deem important, it may help you when you're in deliberations to look back at your notes and remember what was said in the courtroom. Now, if you do take notes, you should be careful that it does not distract you from paying attention to all of the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you do take notes, do not let anyone except the other jurors see them. And then you're allowed to take them in during deliberations, and during recesses in the evenings, you'll leave them on your chair. No one will have access to them. The courtroom is locked. And so no one will have access to look at your notes. When your jury service is over, your notes will be collected and destroyed by the court staff. Now, during the trial, you may think of an important question that will help you understand the facts in this case. You are allowed to ask such questions of the witness who's on the stand. Make sure it's a question that witness would have knowledge of. If it's something that somebody else might have knowledge of, wait till that witness is on the stand. But you are allowed to ask questions of the witness, but you have to wait until both parties have finished their questioning. And when they're done, I'll turn to the jury and say, are there any questions from the jury? At that time, raise your hand, let us know you have a question, write it on the half sheets that are in your binders. The deputy is going to come and get that from you, and the attorneys are going to approach the bench, and they're going to read the question with me, because they do have the right to object if that question would violate one of the rules of evidence, or if there's some legal reason why that question cannot be asked. So they'll come up, they'll look at it. If it's allowed to be asked, I'll ask it, and if it's not, it won't be asked. And so if your question is not asked, it's because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by the members of the jury. Now, if you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately, and we will ask to have it repeated or turn up microphones. Also, I know sometimes jurors in seats 9 and 10 have a hard time seeing. You can kind of come down and sit on the step here if you want, or you can take a seat next to juror number 16 so that you can see the screen better, because I know just the angle of it from those two seats is really difficult to see. So if you want to come down and watch it from here or watch from over there, you may do so. And also, if you need a break and we're not breaking quick enough for you, just raise your hand, let me know, and we'll take a break for you. Okay? Now, during the trial, the lawyers may object to certain questions and statements made by the other lawyers or the witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of this case. Sometimes the lawyers and I will have discussions out of your hearing. And sometimes while you're in the jury room, I may have to take care of other matters that have nothing to do with this case. Please pay no attention to these interruptions. I try to do matters either before you get here in the morning or at lunch after we've dismissed you for your lunch break. So that's why we take a little bit longer than an hour lunch, because we're still doing some work before we break for lunch. But I try not to keep you waiting for us and allow you to go on lunch or break if we have to do something else. But sometimes there's an emergency that I have to take care of. Now, you must not discuss the case with anyone, including your family or your friends. You must not even discuss it with the other jurors until the time comes to decide the case. When it's time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all of you are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to this case, and that includes the media or any of the people that are in the audience here watching. This means that you may not speak to those individuals, even if it has nothing to do with this case. You should be very cautious about speaking to people, because you may inadvertently speak to someone connected with this case. This restriction is necessary to avoid even the appearance of any improper conduct by any person. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you are a juror and you are not allowed to discuss the case. Then, if they continue, leave and report the incident to the sheriff's deputy as soon as you return to court. And that goes with friends or family or anything. Even your employer, when you tell them you're going to be out for 3.5 weeks, they may be trying to guess what case. Just say, I can't talk about the case, and shut down any conversation about the case. Okay, you can't say what kind of case it is. You can't say anything about it. Okay, that's just to make sure no one's putting in their 2 cents. We want you to have your decision based on the evidence and not what some of the people are telling you. Okay. And when the trial is over, these restrictions will no longer apply. And then after the trial is over, you may, if you wish, discuss the case with anyone. Now, the restrictions that I'm about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside of the courtroom. Under the law, the evidence you consider must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from your jury service. It is your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, or listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. You also must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources, like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, the court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you may have of the scene. And you must not share any information about this case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone, you may not post any information about the case on social media websites or in any other manner. How many of you have Facebook, Twitter, Snapchat, any of those types of accounts? Right, okay, so please don't even say, oh, I got picked for a darn jury. Don't say anything on Facebook about your service. When it's done, you can post all you want to about your experience here at Frank Murphy. But please, while the case is going, until there is a verdict, please do not discuss the case on social media or with anyone. If you discover that a juror has violated my instructions, please report it to the court officer as soon as you return. Now you can see that we've chosen a jury of 16. After you have heard all the evidence and my instructions, we'll draw lots to decide which of the 4 of you will be dismissed in order to form a jury of 12. Due to the length of this trial, we picked 2 extra alternates, just in case something happens, because we would not want to have to declare mistrial if 3 of you ended up having some issues, okay? So we picked 2 extras just in case. Now, possible penalties should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. Now, I may give you more instructions during the trial, and after all the evidence has been presented, you will hear the lawyer's closing arguments, and then following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series. Taken all together, they are the law that you must follow. And after my final instructions, you'll go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. Now, it is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not fully be aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments, and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors, who may have different backgrounds and perspectives from yours. Are the people satisfied with the preliminary instructions as given?
Yes, Your Honor.
His defense.
Yes.
With that, we are ready for opening statements. Mr. Elsey will go first, followed by Mr. Brown. Are you going to give yours now or reserve until later?
We'll give it then.
Okay, and you'll be giving it?
Yes.
Mr. Elsey, when you're ready.
Thank you, Your Honor. Just 1 second, Your Honor.
Did you need a break, or are you ready to go right into it?
No, I'm ready. It just somehow the display setting changed since the last time I started it, but I'll be ready in a moment. Good afternoon, ladies and gentlemen. There is a reason that we lock our doors at night when we go to sleep. It is because of people who lurk in the night, people who could do us harm. And this case is about one such person, a person who you will see on one particular night prowled through our community looking for opportunities to go into spaces that weren't his to go into, and to take things that were not his to take. And the most important thing that he ended up taking that night was the life of a woman named Samantha Woll, who you will hear was a somewhat prominent member of our community, the president of the downtown synagogue. And on the very last night of her life, on a night when someone was lurking in her neighborhood, she left her front door open. She gave him an opportunity to take from her. And that mistake turned out to be tragic, because at her home, at a place where she was supposed to be safe, she was stabbed to death. And the evidence in this case is going to show you that the man who did this to her is this man right here, the defendant, Michael Jackson-Bolanos. They didn't catch him until close to 6 weeks after her death. But when they did, he still had her blood on a jacket that he wore that night and on a backpack that he wore that night. Now, I want to walk you through the evidence that you're going to see and hear throughout this case, but I want to frame some expectations and some understanding up front, because when Samantha Woll's body was found outside of her home on October 21st, 2023, her death was a mystery at that time with very few leads. And you're going to see that this case was investigated by something called the Homicide Task Force, which includes homicide detectives from the Detroit Police Department, investigators from the Michigan State Police, and personnel from the FBI who worked together to identify Samantha Woll's killer. And part of what you're going to see in this case is the many steps that were taken in this investigation to show you that this was an investigation that started out very open-ended at first, with other suspects, other persons of interest looked at. And the investigation used cutting-edge investigative techniques, including forensic data from various sources, including forensic science, to zero in on the defendant. And I want to caution you, the presentation of this sort of forensic data, it's not splashy. Despite the camera that you're going to see in the courtroom throughout the trial, it shouldn't be dramatic. It's tedious. It's time intensive, which is why this trial is going to last so long. So I'm going to ask for your patience throughout this process. And that's especially so because for the first few days of the trial, you're not going to see any evidence even directly implicating the defendant. Instead, we're going to show you the same evidence that investigators had to work with at the early part of this investigation, the same clues that they had, the same limitations that confronted them, and the same foundation of evidence that was ultimately put into place that led them to the defendant. Now, Samantha Woll lived in the Lafayette Park neighborhood of Detroit, just across the I-375 freeway from this courthouse. And she lived in a community of townhomes. And on October 21st of 2023, at about 6:20 a.m., one of her neighbors found her body outside. She was outside of a unit right next to hers, 1368 Joliet Place. She was bloody. She was barefoot. She was cold to the touch at that time. When the police arrived, they found a trail of blood that led from her body to her townhome at 1366 Joliet Place. There was blood on the door. Inside the hallway leading to the living room, there was blood on the floor. There was blood smeared on the walls. Inside the living room, there was more blood. Pillows and blanket on the floor. Her contact lenses on the floor, suggesting she had been asleep before this attack happened. And when the police started to investigate her activities leading up to this night, they found that she went to a wedding in Sterling Heights that night and got home at about 12:30 a.m. And the police got a hold of her cell phone, which was found near her couch, and they performed something called a forensic extraction on that phone. They got all the data that they could on that phone so they could analyze it and try to see what her activities were leading up to her death. And they found a couple of important things. First, they found that her last outgoing text message was at 1:02 a.m. She simply sent a heart emoji to one of her friends. Second, they found that her phone was last unlocked between 1:29 and 1:35 a.m. That would have been the last time something necessarily requiring human input into her phone would have had to have happened. Her phone was passcode locked. So that narrowed the suspected time range of her murder between when her phone was last used to 6:20 a.m. Now, the police also found that she had an ADT system at her home, an alarm system. And there were sensors for that system. There was one by the front door, there was one attached to the back door, there was one attached to a basement door that led to a common hallway shared by other units in the building, and there was a motion sensor in the living room. And the police went to ADT and they used a search warrant to get data from that system to see if there was any information they could get about the system's activities the night of her death. And what they found was that although the ADT system wasn't armed that night, the system was still collecting data. And they found that at 12:31 a.m., her front door opened, consistent with her getting back from the wedding. They found that at 12:32 a.m., there was motion present in her living room. At 12:35 a.m. until 12:38 a.m., her back door briefly opened and then shut. And when police arrived, they found that the door had been shut and it was in the locked position when they arrived. At 1:01 a.m., there was a message in the data indicating that the front door was still open, and there's no indication that the front door ever closed that night. At 1:24 a.m., there's an indication in the data that that living room motion sensor was idle, meaning it wasn't detecting any more activity inside the living room at that time, any more motion. The next time that activity was detected, the next time motion was detected in the living room was at 4:20 a.m. And the system was idle again at 4:22 a.m. So that naturally made 4:20 an important time in this overall timeline, because that was the last time motion was detected in her living room after she stopped using her phone. Now, the police went back to the scene a couple of weeks later and they tested the ADT system and they pulled another data set to try to see whether the system was working and to see whether the times were accurate. And they found that the times that were in the data were accurate within about 12 seconds of real time. You're going to hear that an autopsy ultimately concluded that Samantha Woll died of a total of 8 stab wounds. All of the wounds were concentrated at her shoulders and above, focused on her neck and her head. This is the general information that investigators had to work with at the outset of the investigation. But there were limitations. There wasn't a video inside of Miss Woll's home that showed what happened. They looked for videos of other townhomes in that area to see if they could find anything capturing who came and went that night, but they couldn't find anything. They canvassed the neighborhood for eyewitnesses to see if anybody heard or saw anything relevant that night, and they didn't find anything. The closest thing they found was, you'll hear from one of the neighbors who will tell you that he heard what he describes as a woman's voice at around 1:24 a.m., but it sounded to him like an older woman's voice and nothing violent. Now, there was a lot of blood at the scene, but that blood, to the extent it was tested, was identified as Miss Woll's blood. There were some fingerprints left at the scene, mostly in blood on the walls. And you're going to hear that many of those prints were not of sufficient quality to be analyzed to identify someone, and those that were came back to be Miss Woll's. There were footprints in the blood on the ground, but the footprints were bare footprints, suspected of being hers. The police talked to people at the wedding that she went to, but they couldn't find anything suspicious that had happened that night. They talked to dozens and dozens of people, friends, colleagues, family members, current, former romantic interests, but they couldn't find anything alarming or actionable. They couldn't find anything that led them to a true suspect. Now, the first major potential break in this investigation happened on November 7th of 2023. And that potential break, you will hear, was something that didn't even involve the defendant. You're going to hear that Ms. Woll had an ex-boyfriend named Jeffrey Herbstman. And you're going to hear that on October 22nd of 2023, the day after Ms. Woll's body was found, Mr. Herbstman came in to speak with the police and gave a statement and was cooperative. And he will tell you that the last time that he saw Ms. Woll was on October 7th, after seeing her at synagogue. He will tell you that the night of her death, he was home after he returned from synagogue, and he stayed there all night. He will tell you that they dated for about a year, from approximately October of 2022 until July of 2023, but that their breakup was generally amicable. But you will hear that Mr. Herbstman has a history of depression and that he did not take her death well. And on November 7th of 2023, you're going to hear that he was in Kalamazoo for work, and he called the police during what he will describe as a panic attack. And when the police came and questioned him about why he was upset, you will hear that in a frantic state, he told them that he had essentially convinced himself that he may have killed Miss Woll. But he couldn't remember anything about it. And he couldn't articulate why exactly he felt that way. Now, because Mr. Herbstman made that incriminating statement, when he testifies at trial, he's going to testify with something called use immunity. And what use immunity means is we can't force somebody to sit in that witness chair and acknowledge that they previously made an incriminating statement. And so for the hour or so that he's in the witness stand, whatever he says can't be used against him in a future criminal proceeding. But you will hear that what he says is not anything that could be used against him in a future criminal proceeding, because he will tell you that he had absolutely nothing to do with Samantha Woll's death. And he will tell you that when he said what he said on November 7th, he had just gotten an increased dosage of the antidepressant that he was on. He used some cannabis, and he had this one-time delusional panic attack that set in and prompted him to feel what he felt and say what he said. But because he said what he said, he was deemed a suspect, and the police looked into him, and they tried to collect evidence against him. And they had this ambiguous statement from Kalamazoo. You're going to hear, though, that the police did not find any evidence placing Jeff Herbstman at the scene the night that Miss Woll was killed. They didn't find his DNA at the scene. They didn't find his fingerprints at the scene. You're going to hear about a lot of video that was collected from surrounding areas. He didn't materialize in any of that video. You're going to hear that they didn't find any evidence that he left his home that night, that his phone placed him at his home the entire night after he returned from synagogue, consistent with his statement. You're going to hear that they searched his cell phone. They downloaded it and forensically extracted at two different points. First on October 22nd when he first came into the police, and then again in Kalamazoo when he was taken into custody after he said what he said, and they didn't find anything incriminating on his phone. You're going to hear that they tore up his car, they tore through his home, and they didn't find any physical evidence connecting Jeff Herbstman to Samantha Woll's death. They found a knife in his car, a pocket knife. It was forensically analyzed. There was nothing relevant found on it. They found a couple of items in his car, including a dog collar that initially tested positive for suspected blood, but it turned out not to be human blood. Samantha Woll's blood did not show up in his house, in his car, on his clothing. And Jeff Herbstman was eventually released and cleared as a suspect. Now what you will see is that when he was released, it was publicly reported that a suspect was released in this case on November 11th of 2023. And the very day afterward, it was later found, once the defendant's phone was recovered, that the very day after that news report was made that a suspect had been released, the defendant was searching the internet for how to get out of town. Detroit same-day passport showed up in his search history for that day. Now, while some of the investigation team was focusing on Jeff Herbstman, another part of the investigation team was focusing on the one other major lead that they had, and that is some video from near Miss Woll's home. Near her building, there is an elementary school called Chrysler Elementary School, and that school has a camera that points down Joliet Place. The camera isn't positioned such that you can see Miss Woll's unit or her building, but you can see the parking lot that Joliet Place dead ends into that is close to her building. And when police got a hold of that video, they scoured it. They looked at hours and hours of that footage. And what they found was that at 3:52 a.m. and at 4 a.m., just before that motion was detected in her living room, there was a figure in that parking lot who appeared to be tampering with some cars. Now, this caught investigators' interest because it tended to suggest that here we have someone engaged in criminal activity in the same area of Miss Woll's murder on the same night of her murder. It was also something that caught investigators' interest because that very same night, one of the cars that was parked there, and it's not visible in this still shot, it's just to the left of the green circle where the tree obscures part of the image, but one of those cars had its tires slashed that same night that Miss Woll was stabbed to death. So the police engaged in a colossal effort to pull as much video as they could from all of the surrounding area, any building they could find that had a camera on it, to try to retrace the footsteps of the individual that they saw tampering with cars in Miss Woll's parking lot. And they pulled video from dozens and dozens of locations. And when they analyzed that video, they got a pretty good sense of what this individual's trajectory was during the night of Miss Woll's murder. And when they were able to identify that individual's position at specific places and at specific times that night, the FBI went to T-Mobile to see whether T-Mobile could identify any cellular devices that were consistent with being in some of those same locations as this individual at the same time as the individual was depicted on video. You see, these phones that we carry around with us, they're constantly interacting with cell towers. Even when we're not making calls, data is being sent back and forth from our phones to cell towers. And our providers, like T-Mobile, keep records of that data. And that data can give investigators a pretty good idea, not a perfect idea, but a pretty good idea of where our phones have been at specific times. And when the FBI worked with T-Mobile to identify devices consistent with following the trajectory of the person identified in the video, they found that there was one device that matched that trajectory, and it was the defendant's phone. And you're going to see through a combination of that cell phone evidence and video, you're going to see the defendant's route that he followed that night. And you will see that at 12:42 a.m., just as Miss Woll's night was ending, as she got home from the wedding, the defendant's night was just getting started. And you're going to see at that time, he left his girlfriend's apartment in Midtown, Detroit. He was wearing a black North Face jacket. dressed all in black. You're going to see that at 1:44 a.m., and in between these two times, 12:42 and 1:44, you're going to see that a combination of video and phone records trace him going from the Midtown neighborhood south into downtown Detroit, across downtown Detroit, and then over to the Lafayette Park neighborhood right near Miss Woll's home. And you're going to see that at 1:44 a.m., he is in that neighborhood. He's just about a block away from her home, and he's still wearing that North Face jacket. And you're going to see that phone data suggested that he stayed right around that area for about 18 minutes on a night when her door was open, the first time he passed through the area that night. You're going to see that at 12:16 a.m., and this comes from materials recovered from his cell phone, that at that point in time he took a video from inside a secured parking garage at a building called the Ducharme Place Apartments, which is just down the street from Miss Woll's home. He simply took a video of a car and then later texted it to his girlfriend. You're going to see from there, phone records and video then trace him leaving the Lafayette Park neighborhood and going into the Rivertown neighborhood, and that at about 3:05 a.m., he's observed on video going into a parked car and emerging with a white bag. And that white bag is important because in some of the video going forward after this 3:05 a.m. mark, the video is a little grainy, and it's hard to see exactly who you're looking at. But you will see that in the grainier video, that the person that's being tracked is carrying a white bag. And you will see that the person tampering with the cars in the parking lot right near Miss Woll's home, right before motion was activated in her living room, was carrying a white bag. You're going to see that at 3:12 a.m., video and phone data places him in the Harbortown area, where he is observed jumping over a brick wall into another secured parking area to tamper with more cars. You're going to see at 3:24 a.m. that he crosses back over Jefferson and starts moving toward the Lafayette Park neighborhood again. And at that point, at 3:24 a.m., he's wearing the North Face jacket, he's carrying the white bag, and he's wearing what appear to be blue surgical gloves while walking alone in the middle of the night. From there, you will see that the phone data traces his route back toward the area of the scene, where you will see this individual tampering with cars in the parking lot near Miss Woll's home. There is a gap in video between 4 a.m. and 4:20, but you will hear from the FBI special agent who mapped the defendant's phone records that during that time, and especially at 4:20, at the very moment that that motion was activated in Samantha Woll's living room, that the defendant's phone was consistent with being right in that area. And in fact, he will tell you that if he had been looking for the defendant in real time at that point, using the data that he has, that's the very first place he would have looked for him. You're going to see that at 4:24 a.m., after that motion ceases in the living room, that the defendant is then on this side of the freeway, on the other side of the freeway, moving away from the scene, still wearing the black North Face jacket, and now wearing what appears to be a gray backpack, something that he acquired along the way. You're going to see that video and phone records then trace him going back to his girlfriend's Midtown apartment, where he arrives and is welcomed by her at about 4:55 a.m., still wearing the gray backpack and the North Face jacket. Now, the police arrested the defendant on November 30th of 2023. And when they arrested him, they had a search warrant to search that apartment, his girlfriend's apartment in Midtown, located at 454 West Alexandrian Street. And when they searched that apartment, they found a North Face jacket that looked an awful lot like the one he was wearing on video that night. And that North Face jacket was sent to the Michigan State Police Crime Laboratory to be forensically analyzed. And they found that there were 2 spots of blood still on that jacket. And that blood was swabbed, and it was tested for comparison with Miss Woll's DNA to see if her DNA was in that blood, to see if that was her blood. And you're going to hear that forensic scientists, when they testify, they don't talk in terms of matches or certainty. They talk in terms of probabilities, scientific probabilities. But what they found was that the probability, the likelihood that that blood on his jacket was Miss Woll's blood was astronomically high. For a swab of the blood from the higher right sleeve, they found that it was 2.2 trillion times more likely to be her DNA in that blood. For a lower right sleeve swab, they found that it was 32 quintillion times more likely to be Samantha Woll's DNA in that blood. 32 quintillion is a number that is so large, it is 32 followed by 18 zeros. Now, when that jacket was found and recovered 6 weeks after Miss Woll's death, there wasn't a lot of blood on it. It wasn't visible to the naked eye. But forensic scientists have tools to locate hard-to-find blood, to locate blood that could have been concealed in some way. One of those tools they have is something called an alternative light source. It's kind of like a black light. And interesting, you'll see that the defendant searched the internet for the phrase, black light sees what? October 31st, just over a week after Samantha Woll's death. You're also going to hear that this particular jacket was washed. Now, you're going to hear that when the defendant was in custody after his arrest, he placed a recorded phone call from the Wayne County Jail to his girlfriend, who's named Tierra White. That's the woman whose apartment he was staying at, the woman who saw him off before he left the night of Miss Woll's murder, the woman who greeted him when he came home. And you will hear on one particular recorded call from the Wayne County Jail that they discussed this jacket. They discussed this jacket. And she told him that she washed the jacket. As they were discussing why there wasn't a lot of blood on the jacket, she told him that she washed the jacket. And as soon as she told him that, you will hear that that call suddenly ended. And you will hear that several minutes later, he called her back and he lashed out at her for saying that. And he said, and I quote, "I don't want to hear what you got to say about that shit." Now, at any rate, when the police arrested the defendant on November 30th, they also searched his vehicle that he was arrested in. And inside the vehicle, they found a backpack that looked a lot like the backpack that he was wearing that night. And that backpack, it turned out, still had some visible blood on it, a small spot that's still visible to the naked eye. That blood was swabbed and sent to the Michigan State Police Crime Laboratory, and they found that it was 20 septillion times more likely to be Samantha Woll's DNA in that blood than somebody else's. And again, that is a number that is so high, it's even bigger than a quintillion. It's 20 followed by 24 zeros. Now, when the defendant was arrested on November 30th of 2023, he was given his Miranda rights and he agreed to make a statement with some detectives. And you're going to hear that during the course of this statement, he provided 4 different versions to them about what his activities were the night of Miss Woll's death. You're going to hear that at first he denied he was engaged in any criminal activity whatsoever. He then claimed that he was out taking pictures of cars for other people to steal, but that he didn't do anything wrong himself. He then claimed he may have tried a couple of car handles but didn't take anything out of cars, and then finally acknowledged that he broke into cars and broke into parking garages and took things that weren't his to take. you're going to hear that during the first part of this interrogation, that the investigators did not tell him that he was under investigation for a violent crime. They did not tell him that he was under investigation for Samantha Woll's murder. Yet, during that first part of the investigation, he repeatedly volunteered to those detectives, even though there was no mention of violence on their end, that he didn't do anything violent to anybody. He didn't hurt anybody. He didn't rob anybody. And you're going to hear that he had no innocent explanation for that blood that was ultimately found on his jacket and his backpack. He denied seeing any body. He denied seeing any crime scene. He denied seeing anything out of the ordinary whatsoever. Now, when he was arrested on November 30th of 2023, there were also some knives that were recovered. There was a knife recovered inside his girlfriend's apartment, a pocket knife that was inside of a men's jacket, and there was also a knife that was recovered from his own person when he was arrested. And you're going to hear that when he was originally arrested, he was pulled over in Roseville. And the trooper who placed him under arrest patted him down but didn't find the pocket knife. And so he sat there with this trooper on the way downtown for about 30 minutes without letting him know that there was a pocket knife on him. It was finally recovered once he got into the interview room at police headquarters. And when asked about the knife, the pocket knife that he had on him and why he had it on him, he said that he carried the pocket knife on him as a seatbelt cutter, to cut his seatbelt off if he ever got into an accident. He was released on November 30th pending the DNA testing, but when the initial DNA results came back on December 10th, showing the blood on his jacket, he was taken into custody again, and he was questioned again. And again, he had absolutely no innocent explanation for how Samantha Woll's blood got on his clothing. So in sum, ladies and gentlemen, you are going to see that on a night that the victim left her door open, that the defendant was in her neighborhood engaging in crimes of opportunity, that she was stabbed to death that night, and that her blood was still on his clothing weeks later. As a result of this, the defendant has been charged with murder, he's been charged with home invasion, and he's been charged with lying to the police. And at the conclusion of this case, I'm going to ask you to find him guilty of each and every charge. Thank you.
Thank you, Elsie. Mr. Brown?
Good afternoon, ladies and gentlemen. Now, my version and my reviewing of the facts and the evidence, I believe will be like yours. Completely different than what the prosecutor indicates. Yes, Samantha Woll tragically died on October 21st. However, it was not Michael Jackson-Bolanos who did this. She was stabbed 8 times in the neck, in the back of the head, in the back of the neck. To me, that would indicate a crime of passion. This wasn't just some random person walking into her house trying to steal anything. And another thing the prosecutor would not indicate, nothing of value was taken from her house. She had valuables, her purse was in plain view, credit cards, cell phones, laptops, plain view. Now, I suggest if anybody came into this particular house to steal something and to stab her 8 times, surely they would have taken something of value. Another thing that the prosecutor would not mention, she was beaten up. She had contusions on her face. She had bruises on her face. She struggled. Whoever this was, she struggled with them, and this particular situation took time. This wasn't a situation that took 1 minute to do. It was evidence that there was a struggle in multiple rooms. There was fruit from the kitchen a basket that was knocked over. There was indication that the pillows were moved on top of the blood per their own blood splatter analysis expert, who would testify that it would indicate that the pillows fell on the blood afterwards, which would indicate that there was a struggle, in my opinion. Also, there was a high concentration of blood in the hallway leading out to the front door, which in their own expert's opinion would indicate that the body was there for a time. This wasn't a 1 minute, 2 minute thing. Her body dropped after being stabbed repeatedly, and she was laying in the hallway for a period of time. You're also going to hear testimony from their detective, who would indicate from the pictures that there was a footprint that's leading to the back of the apartment. And where that footprint is, it crosses the threshold of where the motion would detect. There's an OIC who would testify that it takes approximately 218 inches from the front door towards the motion sensor in the back to trigger the motion. These footprints were exactly in the position where they would detect the motion on the motion detection. And then the footprint goes outside. Now the prosecutor wants you to believe that allegedly my client went in there at 4:20, stabbed her 8 times, tussled with her from room to room, and then there's no more item. The system went into idle mode at 4:22. We would have to agree and assume that it takes a period of time in order for the system to go into idle mode. Idle mode is where it's a lack of motion inside of the apartment for a predetermined amount of time, and once that amount of time happens with no motion, the system goes into idle mode. Now, there was tests that were done on November the 9th by the OIC Stockmeyer along with other law enforcement, and she indicated she found out how far it would have to be and for the motion to detect. Now, there was a preliminary examination, and a question was posed to her. Exactly or approximately how long does it take in order for the system to go into idle? She didn't have an answer for that. The question was asked, were you curious of that? Why didn't you determine how long? Because that could narrow down the window of how long somebody was possibly in the house. This test or question wasn't examined or asked for months after that preliminary examination, to the end of April. It's when they finally determined that they wanted to know when or how long it would take for the system to go into idle mode. Now, Samantha Woll was found outside, and you would hear testimony from an individual, Kevin Moore, who indicated he touched the body to see if she was alive. Now, a question was asked of him, if he wouldn't know, of whether or not when he touched that body, did he get blood on his sleeve. Now, of course, the OIC or law enforcement never did any analysis of his clothing, but I just want you to think, if they had, I'm sure they would have found trace amounts of blood on his sleeve or his clothing from just touching the body to see if she was alive or not. She had an ex-boyfriend, and you will hear testimony from him, as indicated by the prosecutor, a Jeff Herbstman, who called the police in a guilt-stricken situation where he indicated that he thought he had killed her. And not only that, that he felt that he was trying to outsmart people. Now, one of the evidences that they say that they use to clear Mr. Herbstman is the lack of his phone being in the location of Samantha Woll's apartment. I just think, if you're trying to outsmart somebody, would you bring a phone? And you'll also hear testimony from officers who indicated when they got a search warrant, they felt that that is a tactic that is used by certain individuals to leave their phone before going to the scene of the crime. You will also hear evidence that Jeff Hersman's location cannot be accounted for from October the 20th at 8 o'clock until the next day. They can't even account for where his phone was at. You will also hear testimony and evidence that he had a camera system in his house, that none of the pictures or footage from this camera could be obtained because they were all either deleted or the memory card was taken from there, but there was an inability to extract footage from Mr. Hersman's camera that could suggest him leaving the location that particular night. He was arrested by Kalamazoo police. He then got on the phone with his psychiatrist, and then his story changes of what he originally said. After taking into custody, stating that he had a lawyer who he couldn't remember her name, got a call from his parents that he was in the police station. They didn't ask why he was there. And the reason why they didn't ask why he was there, because he already had told them. They secured a lawyer from him after him telling them what he had did, just like he told the police. Now, you will hear evidence or see evidence that my client was walking around the city. He was. You will hear evidence that he took a bag out from a car. You will hear evidence that there was some rubber gloves in there that he just happened to put on. You will hear evidence that there was some candy inside the bag that he was snacking on as he walked around. You will also hear evidence from a Detroit police officer, Chad Osmond, who indicated that when Mr. Jackson-Bolanos was arrested, that he in fact told Officer Osmond that, yes, I was in the area. I seen somebody laying on the ground. I walked over to the body to see if they were alive, and I touched her. And I realized she was dead and ran off.
Judge, objection, could we approach?
That'll be stricken. That is referencing hearsay, and you're not to consider that. Any statements that may have said to his officer.
So, you will hear evidence from their blood splatter analysis expert, who would indicate that there was a projection of blood that came from Ms. Woll that was on the wall. Now, you would see video footage of my client who left, was walking around, not covered in blood at all. You would see a copious amount of blood inside of this particular location. No shoe prints, nothing that would indicate that my client walked through a pool of blood in multiple rooms. None of my client's clothes were ever discarded. Now, you will hear evidence that a Tierra White, in fact, washed his coat as a matter of her ordinary course of washing his clothes. She would state that he would wear this jacket, which is more akin to a hoodie, that he would wear, she would wear it, and when he comes home from wearing it, or when she comes home from wearing it, it's thrown into the dirty clothes hamper, and then subsequently washed as a matter of course. Now, the telephone call that was referenced by the prosecutor is my client, at that point in time, had no idea she washed it. He's indicating like, hey, if I did what they said I did with all this blood, I'd have been covered in blood. It would have been covered in blood. And then she makes a statement like, oh, I washed it. Unbeknownst to him, this was news to him, unbeknownst to him that she washed this particular jacket. He never instructed her to wash the jacket. He never tried to discard the jacket, throw the jacket away, the pants he was wearing, the shoes he was wearing. None of these items were ever discarded. Now the prosecutor is going to try to submit multiple knives that my client just happened to have. One of them in an old jacket that he didn't wear for months that they found in a pocket. One of them was in another pouch, and one was on him when he was subsequently arrested the second time. These knives were sent off to be analyzed, and of course, none of the knives came back with any evidence whatsoever that would associate my client with Ms. Woll or being at this particular scene. The only evidence that they have is a trace spot on the back of a sleeve. The back of the sleeve, not the front. There's no blood anywhere on the front of his jacket. There's no blood on the front of pants. There's no blood on the shoes at all. The prosecutor wants to put this theory out that it's possible because he's in the area, and that if he was looking into cars, then he must have went into an apartment to commit a murder without taking anything and violently stabbing her 8 times while beating her up. Now, when he was arrested, they photographed his body to see if he had any defensive wounds, any scratches, any evidence whatsoever that would suggest that he had been into a struggle with somebody, had been into a fight with somebody. No evidence whatsoever. Not even the small inkling. Now, my client was arrested twice. Once on November the 30th, they seized his phone, they seized his car. He made no attempt whatsoever to evade or avoid law enforcement, but quite the contrary. He repeatedly contacted the detectives asking when can he get his property back, calling them every single day, to the fact that I'm sure they were tired of him. Simultaneously, they had him under surveillance. Unbeknownst to him, he went about his lifestyle, going to work, going to home, taking his friend to work, made no effort whatsoever to try to leave, to conceal, or do anything whatsoever. Now, when he was questioned by the officers originally made reference to glasses that my client had previously pawned. Some Cartier glasses, expensive glasses. And if anybody knows about Cartier glasses, they know that sometimes people are, violence happens beyond these glasses. People want these glasses. So when the police are asking him about glasses, he's thinking like, man, what you saying? I found these glasses. I didn't take them from anybody. I didn't rob anybody for these glasses at all. So they were being very vague. So, and he indicated, no, I didn't rob anybody for these glasses. Why would they be talking about glasses? So they failed to mention that was the topic of the conversation. So he's already on guard. They're already using deception tactics against my client. They then indicate that they saw him walk inside of this apartment, and they can pinpoint him being inside this apartment, which was a lie. They said they had video of him going into this apartment, which was a lie, which naturally would put him on guard and say, hey, if I did see her, now I don't want to say anything because now you're saying that you saw me do something that I know is untrue, so now I'm on guard. I don't even want to tell you anything because you're using deception against me. And sometimes deception begots deception. And that's exactly what happened in this particular situation. Ladies and gentlemen of the jury, after all the evidence is submitted, we want you to use your logic and reasoning skills to realize that the time frame that they say that this happened in is virtually impossible. Virtually impossible for him to come in there and stab her that many times, beat her up in less than a minute, and then he's seen on camera at 4:23, not 4:24, at 4:23, walking in front of Greektown Casino, walking towards individuals who were outside, striking. Made no attempt whatsoever to conceal himself. Had he been involved in a bloody murder, surely you're not going to walk towards people. You will be covered in blood. People would notice that as you walk by somebody being covered in blood after the way that crime scene looked. You're going to hear from a witness, James Griffian, who indicated he was sure, he distinctively remembered hearing at 1:38 something that really shook him or really got to him. And he felt guilty about it. He tried to convince himself that he did not hear Samantha Woll scream or make a statement, don't do something. Maybe don't stab me, don't hurt me. He distinctively remembers and tried to convince himself that that wasn't the case because he would feel bad and he felt callous for the next 24 hours, which is around the time of when her last activity of her phone was around 1:30ish is when he heard that. He's then approached again months later by officers, and he changes his story up and says that, oh, that couldn't have been the case. I think it was earlier because I got up to let my dogs out, and then I went back to sleep, and I have a watch to substantiate that, I guess suggesting that he went back into REM sleep. If anybody knows what REM sleep is, rapid eye movement sleep, which takes quite some time to get to, that he went back from walking his dog, from waking up, walking his dog, back to REM sleep in a matter of like 4 minutes, which I would think that it was incorrect. He just wanted to convince himself that he did not hear the murder of Samantha Woll because that would be weighed upon his conscience. So ladies and gentlemen, please pay real good attention to what you hear and just think logically. And I believe you will come back with a not guilty. Thank you.
Thank you, Mr. Brown. So we normally end in 10 minutes. I don't think we'll get any witnesses' testimony in the 10 minutes that we're here. Our normal hours are from 9 a.m. until 3:45. I am going to ask you to try to get here by about 8:45, just so that we can try to get started by 9. Please make every effort to get here. Stay in the hallway till the deputies bring you in. Never ever enter the courtroom without the deputies bringing you into the courtroom, because you could walk in and mix with something that happens to here. So please always wait in the hallway till the deputies bring you in. Okay? So don't discuss the case. Leave your binders on the chairs, and we'll see you tomorrow morning between 8 and 45. Clear the front row, please. Nobody needs to get it out of the jury room. You may bring lunches if you want, and what you can do is prepare in the jury room in the morning if you want to bring food with you. bottle of liquid in the courtroom if you need to drink something from the trial. Jeff, did you need them to fill out the form? Did they fill it out already? What's that? Do you have a form? Jeff? Are they gonna fill it out outside? In the hallway? Okay. If you wait in the hallway, the deputy is gonna bring the form out to you, and have you fill it out, for the court's purposes only. Yeah. We have 14, 15, or 15, 16. Courtroom unlocks at 9 o'clock, the media will be brought up at 9 o'clock in the morning. Hopefully we'll have the jurors here by 9 and have them back in the jury room before things get started. Please let the jury, clear the floor before you go out there. And for anyone who wasn't in here earlier, if you're gonna be watching the trial, please don't use the restrooms on this floor if the jurors are outside going into the restrooms there. I just don't want any appearance of impropriety of people following jurors into the restroom. We don't want to have a mistrial because a conversation takes place that shouldn't take place, okay? So just to avoid any kind of appearance of impropriety, please avoid the jurors if they're out there using the restrooms, go upstairs or downstairs the floor, just to avoid any appearance of impropriety. And you're not allowed to talk to them, anybody with that red badge on. So you can be seated until the jury clears the floor. They're filling out a form right now for the deputy. Anything for the record before we break for the evening?
Yes, in regards to, I guess, maybe you could approach, I'm not sure if you could approach, I can put on the record. Yeah, can we approach?
Yes. So, we are gonna go back on the record for just a moment. I know that there were, some emails and letters going on while we were in the midst of our jury selection about, the press not being up here. The reason why the cameras and the audio were not allowed up here is because during our jury selection process, we do actually call jurors by name, and I don't, it's my policy, it's been my practice the 12 years I've been on the bench, not to have press in the courtroom broadcasting, because we don't want the names of jurors being broadcast out there. Sometimes jurors are giving us personal information, sometimes when they mention what type of work they do, they'll actually specify where they work, and that could lead to someone, if it was being broadcast, that works with them, hearing, they worked with them, or hearing their name and then somehow contacting them and tainting our jury. And so, in order to avoid any kind of taint to the jury, I don't allow the jurors' names to be broadcast, and we don't have a system where it's numbers. The jurors are sent up and they don't know a number of any kind, and we call their name when we call them to the jury box. And so, it's always been the policy not to have the media broadcasting during jury selection because of that reason, for the privacy of jurors, and to not have members of the public know who they are and try to taint them in some way. And as far as allowing other members of the public and the jury to come, or the press to come in, when we started out, we had 65 jurors in here. They took every single seat in the courtroom up from the jury box all the way out. As we got rid of jurors through causes and for-cause challenges, as we got more room into the courtroom, we started to allow members of the public in. I believe at least one member of the press got in yesterday. And today, again, as when we started out, the entire courtroom was full. As we eliminated jurors and we had more room in the courtroom to allow more people into the courtroom, we allowed members of the press and the public to come in. Once we had the jury selected and no more names were going to be called, we allowed the camera and audio in, and they're able to broadcast the rest of the trial. And we're allowed up here at the moment when we started swearing the jury and during the jury instructions and opening statements, and they'll be allowed the rest of the trial to be here as long as they're not broadcasting the pictures of any of the jurors. So, just wanted to, if there were miscommunications going on, we weren't banning the public, we weren't banning people from being here. It was a matter of logistics of this courtroom. The jury panel had to be large in order to pick the jury, and so I hope everyone understood it was not a matter of being banned. It was until there was room in the courtroom to allow more people in, and as soon as we had room, we started letting people in. So, and from this point forward, as many can fit in the courtroom will be allowed to come into the courtroom. So, we will all see you tomorrow morning. We will try as hard as we can to start at 9 o'clock. Hopefully our jury are all here and assembled by 9, and you'll have your witnesses here ready by 8:45.
Correct, John.
Okay, thank you. Oh, are the people satisfied with the way that the voir dire was conducted?
Yes, Your Honor, absolutely.
Okay, and is the defense satisfied with the way the voir dire was conducted and
Yes,
the way we let people in as room allowed?
yes.
Yeah.
Okay, thank you.
never slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up.